Lori Graham is with us as well, our interim administrator. Okay, let's go ahead and call this Program Delegation Rulemaking Advisory Committee to order at 9:01. I want to go ahead and take a roll and have everyone introduce themselves and who they're representing, and then and we'll take it from there. So, Jack Applegate.
I missed the last few minutes of whatever you were saying, Alana.
Sorry. I'm going to go, we're called to order, and we're going to go ahead, and I'm just going to roll through the list of everyone I believe is on the phone and ask you to introduce yourself and who you represent, and then we're going to have some opening remarks from the DCBS director. And then I called on you first, Jack. So Jack Applegate.
Morning, everybody, and thank you for being on the call today and a part of this meeting. It's a critical one for our industry in general. I work for Northwest Code Professionals. I am a building official, an inspector, a plans examiner, in some cases a fire marshal, and I've been in the industry since 1986. I serve on the International Code Council's Building Codes Action Committee, where the building code itself and fire code and residential code are developed and the code changes are evaluated. I also serve on the executive board of the International Code Council Region 2, representing the 5 northwestern states, including Alaska. And I've been both a governmental employee building official for about a decade, and I've also worked as a third-party building code official for about 15 total years. And so I've been on both sides of the fence, and I hope to provide great input and work together to get to a resolution where we can make this all work for Oregon. Thank you.
Thanks. Garth Bachman.
Hey, my name is Garth Bachman. I'm the business manager of IBW Local 48 in Portland.
David Fleming.
Hi, Dave Flemings with Clear Company. I'm a building official, plans examiner, inspector, and have about 35 years in both, covering both private party and jurisdictional work in inspection and plan review.
Daryl Fuller.
Daryl Fuller. I'm the lobbyist for the Oregon State Association of Plumbing, Heating, and Cooling Contractors.
Ed Gormley.
Yes, good morning. I'm Ed Gormley. I work for a company located in McMinnville, a plumbing and mechanical contracting business. I represent the Plumbing and Mechanical Contractors Association as the immediate past president. I'm also the contractor representative for IAPMO, their board who establishes the code. I have a quick question. Is anybody on that represents LOC or the city's individual?
Well, you have a bunch of the city managers on here, myself and William Scott Jorgensen.
But nobody from the board of LOC, or just curious?
We invited LOC to submit members. Sorry, this is Alana, and they submitted some representatives of individual cities. So that's who we have on the rack.
Okay. All right. Okay, thank you.
Sure. Greg Hinkleman.
That was me, Greg Hinkleman with the City of Claska, and I'm the city manager here. On the LLC question, we had a chit-chat with LLC last Friday, and just to let everybody know that they are in our corner, we being the cities that want to see this program with third-party vendors on for building inspection and building officials continue. So that's their position, and they've been a big help, and hopefully they will continue. And for me, here in the city, I reiterate our desire and need, more than anything, to continue the program as it is now, or in the future, something that closely resembles what we have now. So I can continue to use a third-party vendor as the building official, and for our inspections, 'cause I use third-party vendors for pretty much everything else, including planning and city attorney and municipal court judge, et cetera, et cetera. So, find a nice resolution to all this. Thanks.
William Scott Jorgensen.
Hi, William Scott Jorgensen, City Recorder, City of Aurora. Invited by participation through the League of Oregon Cities.
Brian Krieg. Did we lose Brian? Brian, are you on mute?
Yes, I was. Brian Krieg, the lobbyist for the Plumbing Mechanical Contractors Association, the Sheet Metal and Air Conditioning Contractors National Association, the Sheet Metal Workers Local 16, Plumbers UA 290, and then also the Oregon State Association of Electrical Workers. I've represented these groups off and on for over 20 years.
Carl Redmond.
Yes, good morning. Carl Redmond here. I'm the Chair of Government Affairs for the Independent Electrical Contractors of Oregon and electrical contractor.
Aaron Reynolds.
Hello, I am the city manager for the city of Florence, and I also had the opportunity to be called upon through League of Oregon Cities, and we had a nice chat with lobbyist Jim McCauley last week. And we're a city of about 9,000 people on the central Oregon coast. And I come to this by way of using third-party contractors for decades to do our building official and building and inspection services in a variety of forms to meet our expanding and contracting needs for building as the economy booms and busts. And I'm happy to be at the table having this conversation. Thank you.
Great, thank you. Eric Schmidt.
Good morning, everybody. My name is Eric Schmidt. I'm the Community Development Director and the Building Official for the City of Gresham and East Multnomah County. So happy to be here. I'm here representing the Oregon Building Officials Association. Thank you.
Great, thanks. Dan Torres.
This is Dan Torres with Oregon AFSCME. Oregon AFSCME represent workers at the Building Codes Division.
Nick Howard.
Yes, hi, it's Nick Howard. I'm a contested case rep with the Building Codes Division, but also here on behalf of AFSCME as an AFSCME member.
Robert Westerman.
Good morning, I'm Robert Westerman. I'm business manager for International Brotherhood of Electrical Workers Local Union 932. I represent the electricians along the Oregon coast from Lincoln City to the California border. I also sit as president of the Oregon State Association of Electrical Workers, representing all of the IBEW local unions in Oregon.
And was there anyone who called in as we got going that I did not call on?
Yeah, Alana, this is
Sean
Michael
Miller
Van Dyke,
here.
representing the Oregon Building Officials Association. Thanks.
Okay, I heard Michael Van Dyke and then Sean Miller. Go ahead, Sean.
Oh, no, just lobbyists for the Independent Electrical Contractors of Oregon. Thanks.
Okay, great. Thank you. So Director Stolfi, I think, is going to get us started off with some opening remarks, and then we'll dig into the agenda.
Thank you excuse me. Thanks so much, and I won't take up much of everyone's time before we jump into the important stuff we need to talk about, but really wanted to just take a moment to say good morning to everyone. Welcome to the next RAC meeting. My name is Andrew Stolfi. I'm the acting director at DCBS. I was appointed by the governor in early April to replace Lou Savage, who said hello to you at your last meeting, I believe. I've spent the last 2+ years within DCBS at a different division, the Division of Financial Regulation, as its administrator, and the state's insurance commissioner. That division was responsible for insurance and banking, credit unions, securities, and a bunch of non-depository programs. I've had a lot of different roles during my career. I was just one thing I'll mention, that the first job I actually had while I was in law school and right after law school, I was a prosecutor for the city of Chicago, prosecuting building and fire code violations. So I'm really happy to return to some similar issues that I got to deal with during that time in this role, and really look forward to connecting with a lot of you that I haven't had a chance to connect with yet. Also want to thank you for volunteering your time to assist the division and the department in this very important rulemaking process. And thank you for your patience after postponing a previously scheduled meeting. I really do hope everyone is doing as well as you can be in these challenging times. And want to also thank you all for agreeing to hold this meeting remotely. I want to start today also by reminding everyone why we are here. As you all know better than me, for a number of years, we've been dealing with the issue of how Oregon law allows the Building Codes Division to delegate its administrative authority and how municipalities may further delegate that authority. We've received several legal opinions on the issue and have been told by the Attorney General that there are certain legal issues with some aspects of the current model. Based on these legal opinions, the division needs to update several administrative rules related to municipal administration of building inspection programs, which is why we're all here. The purpose of today's meeting is to follow up on some topics you all identified at the last meeting in more detail, and I'll stress that today will not be the last meeting nor the last opportunity for everyone to contribute to this work. The division plans on taking the input you provide at the meeting today and use it to inform a set of draft rules that were presented to you at the next meeting. Against that background, really want to stress just two parameters everyone to keep in mind as we address this rulemaking. And the first is we, as a state agency, cannot change the requirements of statute or of Constitution by rule or through any rulemaking. The second is that we must directly address the issues identified by the Attorney General in her opinions on this issue. And we will, of course, be working closely with legal counsel to draft legally sufficient rules based on the advice they have already provided. So with those parameters in mind, we really want your feedback on the specifics of what our rules should entail within the parameters of the advice we received. We also would really want to hear your feedback on how best to implement our rules for the city's contractors and companies impacted by them. This really is a unique opportunity to hear from an important cross-section of stakeholders, and we really do value all of your input. Finally, just want to remind everyone that the building code staff will be available throughout the whole process to assist you, and you're welcome to contact them or me at any time if you have any questions or concerns about the process. So thanks again for taking time out of your busy schedules to participate in the committee. I think I'm turning it back over to Alana.
All right, thank you. We have a series of kind of discussion topics that were identified at the last meeting. So we're just kind of work our way from top to bottom. Given that we have such a good attendance on this call, and I think everyone on the RAC was able to join us, I'm going to go ahead and call on people rather than asking who wants to speak. And if you don't want to speak on a topic, you can just say pass. And as the director said, it won't be your last opportunity to weigh in. And I'll try to mix up my order of names here. So our first topic is building official role and qualification standards. We're going to run the timer here in the room, which makes some pretty aggressive beeping noises, so I apologize for that, but that'll kind of help us keep track of time and not go too long. And I think I'll just start at the bottom of the alphabet. So building official role and qualification standards. Can I start with Robert Westerman? Do you have anything on this topic?
No.
Okay. Michael Van Dyke.
No, not at the moment. Thank you.
Okay. Dan Torres. Dan, are you still with us?
Oh, yeah, sorry, I was on mute on that one. I apologize.
That's okay.
I'll be quicker next time. Yeah, so I think on the building official role and qualification standards, I think, one of the things that we're really looking for is to ensure that the building official who is, responsible for the oversight of these programs, the delegation of the authority, has sufficient knowledge to enforce the programs, know exactly what they're looking at. And that's one of our pushes that has been from the beginning, that it shouldn't be just an administrator or, in some cases I know they act as the city council as backstop to overview the, any sort of, discrepancies or issues with inspections. And so I think that, I'll let people that are more in this industry, such as the trade folks, talk a little bit more to the actual qualification standards. But I think that, as far as the building official role, I think it needs to be a public employee, as we talked previously, whether that's shared or someone hired directly by the municipality to ensure the full accountability to the public process and transparency. And then qualification standards, once again, like I said, I think there should be some qualification standards, but I'll let those with more technical expertise speak to that.
Okay. Eric Schmidt, do you have anything on this topic?
Yeah, I guess this is, obviously this is a weird format with how we're doing this today. There was actually part of me that was wondering, it seemed like the main topic of all this is around the third party, and the building official qualifications seem to be secondary. So one of my suggestions was going to be, do we want to table this and just focus on the third party? But if that's not the course we're doing, then that's okay. In terms of the building official responsibilities and qualifications, yeah, I think from OBOA's perspective, I know the language that was included in the information you sent out on House Bill 2420. I know that was some language that was worked up in terms of adding some additional standards. I think OBOA did not have a concern with some of those things in terms of raising the bar or clarifying some of the qualifications to be a building official. I know there was some language that we were working on the Senate side. Once the House bill was going to go through, we were trying to work through some amendments and just to help clarify about architect versus engineer and that kind of stuff for qualifications. So I think there's definitely some openness for us to have this discussion. So I guess I'll leave it at that for right now.
Aaron Reynolds.
Hello. Yeah, I agree. The fact that standards are good, and it's good for us all to have a clear understanding of what those should be and what those qualifications are. And I think it very quickly ties into the next topic of the third-party involvement. I think if standards are set and they can be met irregardless of employment, I would be in agreement with that. I don't think just because you work for a municipality all of a sudden means you're qualified and able to perform those services. I think it's more about the knowledge of the industry and of the Uniform Building Code. And those are my thoughts on building officials' role.
Okay, thank you. Carl Redmond?
Yes, thank you. Yeah, so our membership is of the idea that the building official should be an employee of the jurisdiction of which they're performing that role for, and need to be very up on the technical aspects of our program, and need to be that first person that if there is a question with whoever's providing the inspection, whether they're third party or not, that is that next step in any type of appeal process that we can go to and have a consistent person with knowledge of the issues of our industry.
Okay, thanks. Sean Miller?
I think Carl covered it well. I think we do like having someone at the city that could actually keep consistency on the interpretation of the building code. And so having no one there, I think really as it involves with third party at this point. But again, having someone there that, and again, we're supportive of third party. I think it's just a matter of having this knowledge at the city that we can also turn to. I think it's important.
Brian Krieg?
Echoing what Sean just said, I think it's the building official having the knowledge and qualifications that are required. I think the qualifications that we had adjusted on 2420 a couple of years ago seem to be right in the ballpark on that, and the building official should once again be an employee of the jurisdiction. Thank you.
Thanks. William Scott Jorgensen?
I would say that the building official, the third-party building official used by my city is impeccably qualified, and that we would be hard-pressed to find anybody in this state or beyond with that same level of expertise.
Okay, thanks. Nick Howard?
Nothing at this time, thank you.
All right, thanks. Greg Hinkleman?
Yes, my comments are, it should absolutely make no difference whatsoever who the building official is, whether it's an employee or somebody that's contracted, as long as they meet the state certification levels. I'm a municipality of 10 employees, and there is no way that the city is going to be able to hire a building official to be a building official with only 10 employees. I don't have the revenue to do that. I don't have the manpower to do that. By going a third-party route, what is the most cost-effective measure for the taxpayers in my city? So I have third-party vendors for my city attorney. I have third-party vendors for my city planner. Why should this issue be any different? So as long as the state puts out the qualifications of what a building official should be, it should make no difference whether it is a contracted person or a employee. Comments, thanks.
Ed Gormley? Ed, are you on the line?
Yes, thank you. I support the current standards we have. My biggest concern's always been a practical experience or a practical side of it and field experience. And I'll speak later to the third party because I've dealt with that a lot.
Okay. Daryl Fuller?
Good morning, everybody. Obviously, a very different discussion between an inspector and a building official. The folks that I talk to have some trepidation that the final authority is somebody who is not a public employee. The notion that our last line of defense is talk to the mayor or talk to a city councilor, or if you have a problem, as opposed to talking to a professional who is a public employee, is something that we continue to have a certain amount of concern about. Thank you.
Dave Flemings?
Yeah, good morning. So I guess my thoughts, just in following up on the last comment, is that even as a third party, your building official is always answering to whatever jurisdiction they work for, be that the mayor, the public works director, those things. But we'll get into that. As far as the building official role, yeah, we've worked through House Bill 2420. We've worked with OBOA. We believe that the mark we know for the building officials has moved around quite a bit in the last few years, and what the qualifications are at the state level. We believe that those should be higher and a stricter standard to include that experience, and there's national certification requirements that would be great to have in this state on it. So I think as far as the qualification standards, that's it. I think with building official, we all kind of know that, you know, they should be the seasoned person that is leading the staff of plans examiners and inspectors for a particular jurisdiction. And then, yeah, we'll get into whether or not third parties should be able to do that or not.
Okay. Garth Bachman?
Nothing at this time. I'm more interested in the conflicts of interest and oversight.
Okay. Jack Applegate?
Good morning, and thank you for everyone for their comments. I just wanted to address
A couple of comments that were made regarding the building official duties and qualifications. There was a comment made that there was no one there, in some cases, a third party that's the building official of the jurisdiction, and that's simply not true. So everywhere that our third party company works, essentially 50 jurisdictions that we have in multiple states, but specifically in Oregon, each one of those jurisdictions is required to have a certified building official that is managing that program and the inspections and plan review processes. And so that is no different than any other jurisdictional program that the state would approve when they go to renew and assume that program. They have to list who their building official is, who all their inspectors and plans examiners are, all the certifications that they have. And so there's no case where a jurisdiction in Oregon is using a third-party building official that they are not a certified, qualified individual. So I just kind of wanted to get that out of the way. And then there were some questions or comments that someone had stated that they really wanted it to be, somebody with final authority to be an employee of the jurisdiction locally. And even in the DOJ opinions, there were some really bad questions asked, and there was also some comments made in there or information taken, for example, off of someone's website without even talking to the third-party company. And so they didn't realize that third-party might work in 5 states or 6 states. And so a company might provide consulting in the other 4 states that they work in, where it's allowed that they work as consultants for developers and architects and engineers who are trying to put together a quality set of plans. But that was not allowed in Oregon at a certain point. And so companies like ours specifically stopped doing that. So the former director of DCBS misled the Attorney General's office when he indicated that that was something that we were doing. But specific to the building official qualifications, right now in the code, and as allowed in ORS 455.020, the deputy section in 103.3 of the structural specialty code says, in accordance with the prescribed procedures of this municipality and with the concurrence of the appointed authority, the building official has the authority to appoint a deputy building official, the related technical officers, the inspectors, plans examiners, and other employees. And so that's explicitly granted within that. So even if we decide that we need building officials who have to have certain technical certifications, I still believe strongly that we need to develop rules that allow an administrative building official, which is what we've had in Oregon for the last 30 years. The building official certification has never been about technical code knowledge, but going to a state class about administrative rules and architectural barriers. So we have an opportunity to resolve all of this by developing an administrative building official position, so long as they have the technical experts on staff if they're third party. And they have to. You can't do the plan reviews or inspections unless you're certified, and all private and governmental employee inspectors are all required to have the same training, same continuing education, and same certifications regardless of who employs you. So that's all my comments for now. I'll address some more in writing after the meeting, but I didn't want to go too long.
Okay, thanks. So then we built into our guidelines if anyone would like to have 2 additional minutes of response on this topic. Is there anyone who would like to speak on building official role and qualification standards? Okay. Hearing none, let's go ahead and move on in the agenda. The next topic is third-party involvement in program administration. And the following topic is state and/or municipality oversight of third-party inspection companies. I think these are pretty closely related agenda items, so I'm going to recommend we go ahead and address them together. Does anyone have any objections to that? Okay. So we're going to address third-party involvement in program administration and state or municipality oversight of third-party inspection companies. And I'll go ahead and just call on people. I'm going to start in the middle of the alphabet and go down this time. So Sean Miller, I'll start with you.
I haven't done anything at this time.
Okay.
I'm at, sure.
Thank you. Carl Redmond.
Earl, are you still with us?
Yes, I am. Sorry about that. I don't have any comments on that at this time.
Okay, thank you. Aaron Reynolds?
Hello. Yes, I think this is where I bring some practicality to the conversation of how things really work at a city with a third-party contractor. So I wanted to hit on a couple of things. We do have staff at the city who are providing the oversight and the program administration of our building department. I do believe that myself as city manager have the responsibility to ensure that we are meeting the standards of the state and applying the uniform building code. And I choose to do that through a professional and qualified third-party firm. We've been doing that for decades at the city in various ways. We've always maintained city employee involvement in that program. We have a full-time building permit technician who is the face of the program, along with our third-party inspectors and building official. We are always available. We meet the timelines. There is somebody who knows what's going on and can answer the questions from the community and from the contractors that know the code and know our community, and most importantly, are timely available. We live an hour and a half away from Lane County, which is our county seat. We're 3+ hours away from the state capitol. Having a local program is very important to us, and this is the best way for us to effectively and financially deliver this program to our city. They are knowledgeable, they are qualified, and they meet the state qualifications. I think one thing I really wanted to point out, and just to rebut one of the comments made, how do you think a city works with city employees? Yes, city employees may be able to make final decisions, but politics and involvement of the city council are always present, especially in small cities. You are never immune from that, regardless if you're a city employee or not. So the best way and line of defense, if you're concerned about the city council or a mayor meddling in decisions, is to have a professional who's qualified, who knows the business, makes great decisions, is consistent and timely, delivers those services so that your contractors are getting their work done and we keep our economy moving, and that will make your city council pleased. Even if they don't always like the decisions, they can see the consistency and the professionalism getting the work done. So irregardless, you're going to always have that involvement of a city council. And I think, again, your best line of defense is to have a professional administrator or city manager who the city council oversees, and making sure that that city manager, city administrator is involved and is making sure that they're hiring professional, qualified people, whether it's a city employee or a third-party contractor. And so those are my comments. I think that we can be accountable, responsible, and have great oversight and financial administration by being the city manager and having a comprehensive, well-run city, irregardless if it's a third-party provider or a city employee. Thank you for your time.
Eric Schmidt? Eric, hey.
I'm sorry, I'm here. I would say I don't have anything at this time to add other than, again, I think a lot of this still boils down. The Oregon Building Officials Association has been pretty consistent on this, that it seems like we have, like we all know, we have conflicting legal opinions, and we're just trying to figure out, okay, so what is it? And then we can figure out how to work with it. So at this point, I don't have anything else to add.
Okay. Dan Torres?
Yeah, so I think that this is definitely an area in which we've had a lot of discussion over the previous years as far as the oversight of the inspection companies and the involvement with program administration. I think that we're still continuing to, talk about the fact that we feel that there should be some oversight. I think there's some pieces of this that we have mentioned previously that are not necessarily being brought up today yet. But I think that, one of the things that we discussed is ensuring that program administration is being held in compliance with current Oregon laws. For instance, the fact that any usage of funds and collections through building codes can only be used for the enforcement of building codes. And we have people who have stated on the record from LOC that they have heard of or know of, or there potentially are cities in the past that are commingling funds, not using them in designated accounts. So when it talks about third-party involvement of the program administration and oversight, I think one of the things that we've talked about previously and will continue to push if we do down this route is increased transparency and accountability for those programs to ensure the funds are being used. People talk about the cost for the program, but that's the point of those funds only being used for the enforcement of building codes is the monies collected should be ones that are set at standards in order to continue that program and to use those funds for usage of that. So I think when we're talking about oversight of inspection companies and program administration, one of the key aspects of that is the fiscal oversight as well too. Now, I think that when we talk about, there's been a couple questions, and I apologize if I'm deviating from the topic. I think someone mentioned this format is very strange. I feel like it's a combination of presenting topics, but then also trying to counter other people's topics, so it's a little bit weird. But, I think at the end of the day, we do have legal opinions, and I think the one thing that I want to bring out of this more than ever is that we have had a legal opinion for 2 years and subsequent additional clarifications a year ago, and we've been told by people who have been trying to continue the system as status quo that they will be presenting other legal opinions, other legal arguments, and so far we haven't seen any yet. I think in most recent comments they said that some will be coming this summer. We've heard that for years now, that they don't agree with the DOJ, that they don't agree with LLC, that they don't agree with follow-up questions, yet we still don't have alternative legal opinions talking about the clear delegation of this power. And so far, we have to default, in my opinion, to what DOJ has provided us and LC has provided us in follow-up and further questions. So I think when it comes to third-party involvement in program administration, I want to echo the comments before. We're not against third-party inspectors. We think that they serve a vital role in the system, and I think that they provide a co-equal system in which they can provide, support and backfill for counties. The things that we're concerned about is, are we in compliance with current delegation? And we're not seeing that being met in the DOJ opinion, the LC standards, and follow-up questions. And we have no alternate legal opinion that has been presented to this group or anyone that I'm aware of at this point. So I think when we're looking at that, we need to look at both the transparency, the accountability, the fiscal oversight, and then also making sure that we're in compliance with the way that the statutes and the delegation is currently promulgated in our state.
Okay, thanks. Michael Van Dyke.
I would just echo what Eric Schmidt said a little bit earlier, nothing to add. Thank you.
Thanks. Robert Westerman.
On third-party inspections involvement, I think we need to, let me back up a second. I think the basic question here, the elephant in the room, is that we have a DOJ determination that it's illegal to delegate discretionary authority to third-party involvement. And I don't believe that this committee is empowered to make a decision on that legal from the Department of Justice. So what we do need to do is develop rules on how we're going to go forward. And so for third-party inspections, I think we need to ensure that we do list out the discretionary powers that cannot be delegated and those administrative powers that can be, to determine how third-party inspectors can be involved in the future. Thank you.
Thanks. Jack Applegate.
Thank you. I guess first I'll go ahead and make some comments on the topic, but I also want to rebut a few of the things that were said, so I'll save that time for later. But there seems to be this opinion out here that House Bill 2420 was the gold standard and everybody was kind of in agreement and that was going to be approved. And I have to say 100% to the contrary, that was not the case. I truly believe that bill was going to be killed by the Senate. And in fact, in the past 3 years, there has not been a bill, despite some efforts to try and prevent third party from being the building official. And additionally, you look at things in the DOJ opinions and especially legislative council committee opinions that were requested by Representative Holvey, and there's no secret here that Holvey was working close with the previous Building Codes Division administrator. And in some cases, we asked for some copies of the questions that were submitted, and we wouldn't be given those. And we had some concerns about, asking those questions with a specific purpose. And that purpose might be to push one position over another. But for instance, in the February 7th, 2018 Legislative Council opinion, in the very first question and the answer given, they made it very clear that their conclusion is not free from doubt. They also made it clear in these opinions that the opinions didn't represent reviewing a single specific municipal program anywhere within the state of Oregon. And so when we have folks on the call from various cities representing the League of Oregon Cities, and they're all indicating that they believe there is sufficient and qualified oversight of these programs within their own city administration, and then when you have the fact that in the statutes, it's the municipality that assumes the program itself, and not the building official or the inspector or plan examiner, but ORS 455.148 specifically says it's the municipality that assumes the administration. And so if a city or county official who is employed by the county is administering and overseeing that program, now we're down to the building official role. And there seems to also be at least some opinions out there, and maybe they don't understand the statutes or the other levels of oversight that are provided. And even kind of the way the agenda is drawn, it keeps referring back to some of these documents as golden, but even in those opinions, they don't talk about the full oversight picture. And I just wanted to let everybody know, in case they're not aware of it and they're not in these programs working every day and they're more on the other side of the fence, that there are multiple levels of both local and state accountability and multiple layers of protection and oversight. Starting with the local jurisdictional supervisors, our city managers, community development directors. You have the local board of appeals after that if they're still not satisfied. And if that matter is still not resolved, any person is what the statutes say, or any permit holder can appeal to the State of Oregon Building Codes Division chief. And the statutes also say that all inspectors, plans examiners, and building officials must follow a directive of the chief at the State of Oregon. Meaning, if somebody appeals even informally to the chief, and the chief says over the phone, building official Smith, you're not interpreting this correctly, you need to allow them to do this, that a code official has to do that, whether that be the building official or the inspector. Now, let's say the applicant still lost, and the chief didn't agree with the person appealing. Then there's still a final appeal. The affected parties can appeal to the specialty code board itself for a final decision by the most technical of experts with the most authority in the state of Oregon to decide on the matter. That's the final decision process. And the building official, although implied in some of the legal opinions and by some of the folks in the legislative session, the building official does not make a final opinion about anything. In fact, if all of the job site, they use a certificate of occupancy as an example, they can withhold that. No, our code says if they've passed all their inspections and they've met the minimum requirements of the code, the building official shall issue the certificate. So there's multiple examples of questions that weren't asked, of answers that weren't complete, but also I just want to make it clear that there is multiple levels of oversight of third party. And I'll withhold the rest of my comments until the rebuttal time because I'd like to address some of the things said about fees. Thank you.
Garth Bachman?
I have nothing at this time.
Thank you. Dave Fleming?
I wanted to speak, I guess, a little bit to each of the two items, third-party involvement. And I think it's important to note how it really works in the jurisdiction. Some of the issues that have been brought up are the fees and how those are done and things. Just so you know that programs are required by law to follow the adopted fee methodology through BCD. All fees are adopted directly from the jurisdiction. Third parties may have some input to that just as advice to their jurisdiction, but it's strictly the jurisdiction that adopts fees and sets fees. even when we take money for a permit, if we're administering, working as the permit technician or whatever position is taking money, all of that money goes straight into the city's accounts. It's not like it comes to the third party and then we keep a percentage and send the rest to the city. It's all done through the auditing and the finance department, just like any other fees, even if it's third party or in-house building department, it works exactly the same way. We always have that protection with it. The difference in, the third-party involvement and administration is that those third parties, as was mentioned by an earlier testimony, that we always answer to jurisdictional employees. We always answer to a city manager, a public works director directly. That is by our contract. When we work with a jurisdiction, that's the way it works, is we have someone that administers that contract that is that jurisdictional employee. And as a contract employee, we can be dismissed at any time. If they're not happy with the service, the customer service, the professionalism, any of the rest of that, they can at any time choose to dismiss us by that. So that's kind of a little bit on third party. On the state and municipality oversight, third parties are licensed separately through ORS 455, 457. There's a whole additional set of rules and insurance and requirements that a third-party business has to meet in order to be able to even contract for this work, in addition to all of the required state certifications for the individual inspector or building official with it. So we have all of that. I think it's important to note on that oversight that this legal opinion that's been talked about, the DOJ opinion dated March 14th on it, when it comes to the non-delegation clause, the opinion itself states that the relevant test is whether a public body exercises sufficient control to adequately safeguard against arbitrary and unaccountable exercise of governmental power. And that's really our question, is what is the right level of oversight for a jurisdiction to keep us within the opinion, within the state regulations that we currently have? What is that right level of oversight? And I think that's what we need to delve into and to get to and make sure that our cities are protected by that.
Okay, Daryl Fuller?
No additional comments at this time.
Ed Gormley? Ed, are you there?
I have a little different, I am, yes. I have a little different perspective on all of this. I spent 40 years being involved in our local government here, and I have nothing but empathy for the small cities that just don't have the staff to do it. McMinnville's been through that over the years. My concern, though, as a user of all this, has been the quality of the third-party folks. And I've been involved as an expert witness in lawsuits related to companies that cities have hired. I don't know if it's, I'm talking about right today in 2020, is it better than it was 5 years ago? I don't know. My concern is I pay money for fees. I represent customers that want work done. The role of the building inspector officials and all that are all about, the quality and making sure I do my job right and that the public's protected. I wondered, has anyone ever done any evaluation or talked to contractors about, the use of these folks in that? I think you'd be surprised what you see on some of them. So I think there's a role for third-party people, but the quality has got to be vigilantly maintained. And I'll give you as an example. I got the letter from the city of Florence. I happen to know someone that was in business in Florence, closed their business, so I called and I said, tell me about how it's been when Lane County was doing the work versus city of Florence. He had nothing but praise for the city of Florence because working with Lane County was next to impossible and take days to get things scheduled, and the quality of service was tough. So you have these small areas that that need this service provided, and homes that have timelines and things like that. So I think each area has to be kind of evaluated on its own. I think if I'm not mistaken, I believe that cities adopt enabling ordinances to adopt and enforce the building code, and those cities that can't do it, maybe they shouldn't be doing it, and let other organizations do it, like the county and that. So anyway, my concern is that some of the smaller cities, this is the best way they can do it. They can't rely upon the county, because the county is overworked or undermanned and can't provide decent services in some of the small towns. So that's it.
Thanks. Gregory Hickelman?
Yes. I won't add much, just I want to echo the comments that Mr. Gormley just said, and Mr. Fleming, and my compatriot Aaron Reynolds down there in Florence about the importance of us cities, we cities, especially us small guys, having the ability to use the third-party vendors for building official and inspections, and also Mr. Applegate's comments too. So that's all I got.
Nick Howard?
Nothing at this time. Thank you.
William Scott Jorgensen?
I think if I was in a position where I kept hearing complaints from contractors of various projects that I work closely with regarding the building inspectors, regarding the building officials, that's a conversation that would then happen at the council level, and that we would have the option of terminating that contract, and we probably would. So what we have right now is a situation where everybody's pretty happy with what we've got, and people do try to exercise political influence. I've had instances of people working on projects, trying to call the mayor to get his permit issued, more quickly, but that's dealt with administratively and properly.
Brian Krieg?
Yes. On this topic, some of the issues that we have discussed in the past that are, I think, are definitely needed are routine audits of the programs that take the third-party officials on as their methodology to get either the building official role or the inspector's role done. Companies are involved for profit, and over the 20 years of back and forth on this issue at different times, I've seen quite a few different issues go on. There's parts of the statute that talk about not being able to surrender a program and take it right back. We had a lot of games at one point in the past on this issue. The constitutionality issue for the discretionary powers is what's driving the conversation for today, and the need for the rules change, some type of rule changes out there, and I think we need to keep going back to that. If there are other legal opinions out there, they need to they should have come forward by this point in time. This is not a new issue that's been in front of us. Thank you.
Okay. Would anyone like to make a response on these topics?
This is Jack Applegate. I would, please.
Okay. Anyone else? All right, go ahead.
Dan Torres. I've got two things to add after Jack's.
Okay. Anyone else? Okay, go ahead, Jack.
Thank you. I just wanted to talk a little bit about some of the comments made about needed oversight for third-party programs. Again, I think if we're looking at oversight, it needs to be for all building department programs. Dan mentioned specifically about funds commingling. Well, that's not something that's been brought up as something that third party is doing. Again, third party does not set the fees that the city puts in for their permit fees. In other words, those fees have to be approved by their local city council. The public is given an opportunity to appeal those fees and how they're setting them if they want. But as far as how those fees are applied, they have to use Oregon standard fee methodology as a plans examiner calculating the fees, as the city permit technician who is overseen by the the administrator at the city, the planning director typically. And so the city is the one who sets the fees, charges the fees, collects the money. And in some cases, I was the one who reported commingling of funds and jurisdictions, even when I was a building official for the city of Astoria for about 8 years. I reported it at a adjoining jurisdiction that was not third party, and the local building official was quite frustrated. And so I do believe that sometimes there's administrators who like to kind of dip into this fund and they're not allowed to do so. But I also feel like the state did their job, and when they heard it going on in multiple jurisdictions, on the North Coast at least, the state sent a representative out who talked to the city managers and kind of gave them the unofficial knock it off, so that they would quit doing that. And so I believe that one of the things that Dan brought up that was a good point in the previous meeting is that there needs to be more employees available at BCD, and we need to, in my opinion, bring back the program reviews for all jurisdictions, because these issues that some people are bringing up can be resolved.
Okay. Thanks, Dan. Jack, that was your time, but I think we've got a topic coming up to talk about reviews and audits, so that'll be a good opportunity there. Dan, you want to go ahead? Dan Torres? Dan, are you there? Okay. We will circle back. Just check one more time. Dan, are you there? Are you on mute? Okay. So the next topic on our agenda, definition of sufficient control, sufficient procedural safeguards, also seems pretty related to these previous two. So I'll just go ahead and ask if anyone would like to speak specifically on agenda item D, definition of sufficient control or sufficient procedural safeguards. Was there anyone who would like to speak on that topic? Okay. Hearing none, let's move on to program renewal, reviews, and audits, which has come up a little bit. I will add to that, just in terms of renewal, one of the issues I would like to hear from the RAC about it is what a timeline would look like in terms of when cities might be ready to renew. So I'll go ahead and start at the top of the alphabet for this one. So Jack, do you have anything for program renewal, reviews, and audits? Uh-oh. Can anyone speak up? Are we having technical difficulties? Why don't we take a break? We're going to call back into the conference line. We'll take a break from streaming for a moment and come back in a couple moments, and hopefully we can get everyone connected. Okay, go ahead, Dan.
No. Okay, great. Thanks so much. And I just want to clarify really quickly, my comments earlier about oversight of funds, that wasn't necessarily directed at third parties. That was just mainly about the cities. I think Jack cleared it out himself. And my comments were specifically in response to comments from LOC representatives about, yeah, there are jurisdictions that may ever have or currently are commingling funds. So I just wanted to clear that. But I think one of the things that got brought up about the actual practical application and how independent contractor, how third-party inspectors are hired is an issue that I want to really flag as we're looking at this, since this is our opportunity to get these rules done right and how these rules work within our system, is an issue that I brought up at the very beginning of this discussion years ago when we were talking about third-party cross-permit specialization. And we talked about this idea of, are these third-party contractors real, or are these third-party inspectors really passing independent contractor laws? DOJ had some questions about that. There was a response from somebody from a third party that said, oh yeah, we make it clear, we call them independent contractors, it's in their contract language. And DOJ responded, well, just because you call them independent contractors doesn't mean that they certainly are. And so one of the things that I wanted to flag, since we were talking about the process of hiring third-party inspectors, is I asked that the Rule Advisory Committee and the agency, when they're building these rules, really look to ensure that the laws that are put on how these work are following our independent contractor laws. Because we know it's not just calling somebody an independent contractor, there's actually tests and standards set for that. So I just wanted to add that piece in there. I feel like this was a section that most fit for that. So.
Okay, thank you. So the next topic on the agenda is a definition of sufficient control or sufficient procedural safeguards. This one, I think, is also pretty related to the last two we've been speaking about, so I thought I would just ask if anyone had anything they'd like to say specifically on sufficient control or sufficient procedural safeguards.
This is Erin. Yes, I would like to say something to that.
Okay. Anyone else?
Yeah,
Yes,
Dave Fleming?
Jack, I would as well.
Jack. Okay. Anyone else?
Fleming.
Did you get Dave Fleming?
Yes. Okay, Erin, go ahead.
Thank you. I do think this is the heart of the matter, this topic right here. I do want to remind everyone there was that revised opinion, as somebody just mentioned, and it does give room for us to have this discussion and make sure we're all on the same page about what sufficient control and sufficient procedural safeguards are. As one of the commenters said, what is that answer? What is the right level of oversight? And then let's figure that out. Let's make sure there's adequate timeline for municipalities and counties to implement that. And when I mean adequate timeline, definitely not 30 days, preferably at least 6 months. And let's make sure there's procedures in place at the state, the BCD, that going forward, that we don't have these concerns or that we don't think the minority infractions that have occurred in the past are the norm. Those are not the norm. Those infractions are the minority. Let's make sure we have policies and procedures in place to audit at the state level and ensure that those adequate safeguards are in place at the program level. Again, it's not a get-out-of-jail-free card if it's a public employee working for the city or the county. That doesn't just automatically mean everything's perfect and great. I do think there needs to be that level of audit authority at BCD that actually happens to ensure that these fears of commingling and just poor oversight of these programs are or are not occurring. And I'm getting off topic here, but I do think we just need to circle back around, agree what that is. We want to be in compliance as a city. We believe we are, and just don't assume that everyone interprets that opinion just automatically means, oops, we can't delegate that authority to someone. I don't think it means that. I think it means that we need to have the right level of oversight in place and safeguards in place. Again, I think we do, and I'd like to find a way that we can all be on the same page and be in compliance.
Okay, thank you. Dave Fleming?
Yeah, I want to echo a little bit of what Aaron had mentioned. The opinion does say, the issue here is that the jurisdiction has sufficient safeguards in place and that they maintain that governmental oversight. I think we need to work on, as a committee, we need to work on establishing what those safeguards might look like, what they should be. I think, much like Aaron stated, we're going to find that most jurisdictions already meet those standards or pretty close to meeting those standards for what normal government oversight would be. Whether it's third party or not, you need to have those for your program. Even you don't want a jurisdictional building official to just be able to run amok, and the government structure is set up that there's oversight at each level for that. Should be no difference if it's a third-party company providing those services or not, third-party building official. You have those oversights already built in. I think that when we get those standards established and outlined, that we'll find out that most of our jurisdictions already meet it, and a lot of this has been a lot of questions or misinformation or based on misinformation in how cities actually operate. Thank you.
Okay, thanks. Jack Applegate.
Thank you, and I do want to echo what Aaron said, and also want to just to make people aware that although the program review would be great, and I hope we can get that started back up again for all of Oregon's building departments, and nothing would help the trades more than that. But in addition, I just want to make sure everyone understands there are already safeguards in place to prevent bad actors. So Building Codes Division in ORS 455.770, that allows oversight of all municipalities, all building officials, all plans examiners, and all inspectors. So this authority is already granted to them in law. But again, I think to echo Dan's earlier things about, I think BCD needs the appropriate staffing in order to be able to enforce that law and to be able to review programs. And in addition to that, the BCD authority, if you go into 770, and it extends to ORS 447, 460, and 693 with respect to that oversight. And so not only do we have multiple levels of appeal, but we also have multiple levels of direct oversight of an individual inspector, building official, plans examiner, et cetera, within that. Also, I would like to bring up to a point is kind of along the agenda and the materials sent out to the committee, we had copies of the House bills again that didn't get passed. But what we don't have is, I believe the LOC and Erin Doyle had her own version of the House bill that she believes strongly would address the issue of proper oversight. And so I would love to see that brought up before the committee as equal consideration to somebody else's House bill that didn't pass. And maybe we could all take a peek at that for some ideas. That's it. Thank you.
Okay, thank you. Would anyone like to respond on this topic? Sufficient control and sufficient procedural safeguards? Okay. Hearing none. Topic E is program renewal, reviews, and audits. I'll go ahead and go down the list on this one again. And I would ask, one of the things embedded in program renewal is kind of what that timeline may look like. I know Aaron mentioned that as well. But we'd be interested in your feedback on kind of an implementation timeline as well for the renewals, reviews, and audits. So I'll start, I don't know, middle of the top here. How about Daryl Fuller?
Nothing additional to add at this point.
Okay, thank you. Ed Gormley?
I would think 90 days would be sufficient. Thank you.
Thank you. Greg Hickelman?
The only thing to add to this subject is the allow us sufficient time to implement or review whatever it is that is being reviewed or audited. 90 days was just mentioned. That may be sufficient, maybe something a little longer. But as long as it gives us, especially as small guys, a chance to do what needs to be done would be great.
Nick Howard?
Nothing at this time. Thank you so much.
Thank you. William Scott Jorgensen?
I've got nothing.
Okay. Brian Krieg?
Yes, one of the things that would be nice to have within the data that's collected on the programs would be to look at the amount of activity and the results in the area of license enforcement, that being both contracting licenses, there's several categories of that, and then the trades licenses.
Okay, thank you. Sean Miller?
Nothing to add at this time.
Thanks. Carl Redmond?
Yes, I support the 90-day period. I think that should be a minimum. And with that notification to have appropriate summary information about the program so that we have adequate time to digest that and make any comments during that review period that would be important to us.
Aaron Reynolds?
Hello. When I was speaking of time period earlier, it was when those emergency rules went into place and we had 30 days to respond and comply to do something totally different than we ever had before. That was a bit constraining and difficult. I thought it was the worst tragedy of my career. Now I've been corrected by the universe and God because COVID-19 is. So it's good to have that perspective in life now. But for program renewal reviews and audits, I think as long as whatever is put into place and we all have a clear understanding of what that is, if you're really doing that work, it should not be difficult to go through a renewal or to have it reviewed and audited by BCD, because you should have the material there and ready on hand for an audit or a review. And then for a typical program renewal, again, as long as things aren't changing drastically and you have your system in place, 90 days should be more than adequate time. That concludes my comments.
Thank you. Eric Schmidt?
Thank you, Alana. On the program review, certainly, I know we've had those in the past. They've kind of died down, but I think there's opportunities to get those things going again in a different way. One thing I know we used to do many years ago is there was kind of a joint partnership between BCD and the the Oregon building officials, kind of a team of folks that would go out and audit and kind of look through the different people's programs, peer review kind of stuff. I think there's an opportunity to kind of maybe take another run at that, maybe include so how do you have industry as well as the building officials and BCD? Is it a partnership that we're looking through and offering up some of those thoughts?
Okay, thank you. Dan Torres?
Yeah, thanks so much. So I think as far as the timeline goes, I obviously want to make sure that, as we're implementing the rules and standards, that we are being responsive to the needs of people that are being impacted by this. And I just have to, for the record, point out that the bill that we worked on, 2420, not only included 90 days after the effective date of the act of when the municipality had to decide whether they were going to continue with contracting under the third-party provisions. So there was 90 days in that. But that 90-day deadline was just to let the BCD director know what direction they were going to go on, whether they were going to come into compliance or whether they were going to relinquish the program and or work on alternative programs. And then they had additional time to come in compliance with that. So, for anyone that thinks that this is going to come quick and fast, we worked a lot, and I think that we worked a lot in good faith to try and provide additional timelines for compliance and options for jurisdictions on this. And what I want to make sure that we are doing, though, is, giving them the time that they need, but not delaying unnecessarily necessarily without just, reason or cause. We passed that bill on the House, we worked on it, and a bunch of folks passed it, and my understanding was that on the Senate side, we were getting close to a finalized bill that would be very similar to 2420, including some initial thumbs ups from people like the League of Oregon Cities and potentially AOC, to the point that we were going to have a vote on that bill before the Republican walkout occurred, therefore ending the bill and killing it. And what I want to continue is that we're working towards actually implementing rules that get us in compliance and not just completely continuing to delay this. So, I think that we should have timelines that do take that into consideration, but at the same time, as we continue to have been working in good faith for the last 2 to 3 years to start with a bill that adds up hopefully becoming more and more feasible for local jurisdictions, I want to make sure that we're doing that in a way that's still continuing to work towards our solution and not just delaying things out, because so far, we've been told to wait for an alternative legal opinion. We've been told to wait until things can be looked at. We worked through 2 different bills through 2 different sessions on this. I think at this point, we need to start getting practical application into practice. So I think we should have a timeline. I think, people have been saying 90 days, and I think that sounds good, but I just want to remind people that the 90 days was in the 2420, and not only that, but it was an additional amount of time that they were allowed to come into compliance. So, I think, once again, I think 2420 had a lot of answers for us. There's been discussion of an alternative bill, a bill that was worked on without parties being involved, that I know of on both sides of the bill, for alternatives, but there was a bill that did pass the House, and in my political estimation was en route to pass the Senate, had the walkout not occurred. So.
Okay. Michael Van Dyke?
Nothing to add, thank you.
Thanks. Robert Westerman?
Nothing at this time, thank you.
Jack Applegate?
Yes, thank you. So I won't go any further into the speculation on whether or not that bill would have passed or what amendments that were being proposed might have passed or not. I think that's kind of just opinion-based, but I do think there was some great work that was done by multiple parties, and Dan's right on that. And I also agree with Dan that in that bill, they had the 90 days for notifying the division of what the city or municipality's intentions were, and then it was almost a year. I think we can go back and take a look at that, but before the implementation. And so whatever the final rules are that are going to affect the municipalities, they're going to have to make their decisions based on whether they can even keep the program or not, and those would go to a county for all those jurisdictions that are not, no longer going to be able to have a local program. And so what my concern is that we don't have a complete crushing of the industry that's really going to kind of harm the affordable housing and slow down permit issuance and inspections. And so I think that using that 1 year as a minimum figure is something we really need to consider. I know how hard it is to set up a program for a jurisdiction and advising and guiding them in doing that. But if we end up in a situation where they're not going to have an administrative building official role, which I hope we don't, but if that happens, it's going to be devastating to about 20 municipal programs, and it's also going to heavily affect the county jurisdictions and some of the other small cities that we serve now who are adjacent, meaning close by to that jurisdiction, so we're able to serve them. And right now we have one of the most critical crises of not having enough technical, qualified, certified code officials across the country, not just in Oregon. And we're supposed to lose another 30% or so in the next couple of years. And so I'm worried that we could leave these jurisdictions without anyone, that in many cases it's taken over a year to find certified individuals in some jurisdictions. And so I think we really need to proceed with caution on that, and hopefully we take a close look at that timeline and maybe kind of mirror what was going to go on with that House bill, as Dan indicated. I think that timeline was a good one. Thank you.
Okay. Garth Bachman?
I had to momentarily step out of the room, and when I came back, I think Brian Krieg was finishing what he had to say. And I thought I heard him mention something about licensing and possibly licensing enforcement. Coming from a licensed trade perspective, the licensing enforcement in Oregon is, in my opinion, very lacking, and I don't know if that has to do with third-party involvement or not. But as far as program renewal and reviews, I think that needs to be reviewed, and we need enforcement in this state. We are behind. At least in my opinion, we are behind.
Okay. Dave Fleming?
Yeah, I want to echo kind of what Jack said, in that the only other issue I have is I know program renewals were split so that it didn't impact BCD with all of the jurisdictions needing to renew it once and being able to review those applications and materials. I'm a little concerned with, we're up now on a pattern where it appears all jurisdictions are on the same time frame, and I'm just wondering if that's something that we also need to look at. And maybe it's not us, maybe it's somewhere in the rules with how we're going to move forward with that. I've got a concern if we've got all of the jurisdictions needing to respond at once. Thank you.
Okay, thank you. Would anyone like to make a response on this topic?
Yes, please, this Jack.
Anyone else? Okay, go ahead, Jack.
Thank you. Just real quick on licensing enforcement. So I want to make it clear, at least from my firsthand perspective of the, 30-some jurisdictions at a time that we're working in Oregon, that all of our inspectors, all of our permit technicians that we provide in some jurisdictions, all of our plans examiners, all of our building officials, they all check for licensing. That rule doesn't change because you work for a third-party company and somebody else is signing your check. And so as recently as in the last few months, we've issued significant citations on behalf of the jurisdiction where the city attorney gets hold of the information from one of our licensing checks on an electrician who was doing work that was not authorized, and they ended up being cited in the local process. And on a regular basis, though, all the time in our jurisdictions, we do enforcement of licensing. And unfortunately, many of our jurisdictions are smaller in size and population base. So we know many and almost all of our local contractor and trade partners. We have great working relationships. And so when somebody new is in town or a new application comes across the counter, those are checked both at the city when the permit application is applied for and at the job site during the inspections. And one of the key things that I guess this keeps being kind of avoided on the trade side is, every contractor out there who's a licensed plumber, electrician, they're supposed to be wearing their visual ID badge. It's in the statutes. They're required to do it. And what would really help code officials is if we could bolster those rules and having them wear those at all times, that would make it much simpler for us. Thank you.
Okay, thank you. So the next topic on our list is conflicts of interest, including architects and engineers and compensation of third-party providers. And in the interest of time, I would propose we also take this opportunity to talk about the next one, workforce development and building official staffing. This seems somewhat related. So I'll just go down the list. So again, conflicts of interest, and then workforce development and building official staffing. I'll start at the middle of the bottom this time. How about Eric Schmidt?
Thanks, Alana.
Thanks.
Conflicts of interest. I know this was language that was that came out previously, and I think it's working overall. I know it's caused some challenges. I think it's something that I think the Oregon Building Officials Association would be interested in talking more about this in terms of unintended consequences that's taken place and just clarity on how those things are applied. So I think there's room for potentially some discussions on that. So I'll leave it at that. Thank you.
Okay, thank you. Dan Torres?
Nothing super substantive to add at this time, other than I hope that we are able to clear this up, because I think it's important that when people are presenting themselves as, you know, delegating, overseeing, or participating in state function of oversight, that any potential conflict of interest is cleared out. And, you know, if there are situations where there are building officials and building inspectors that also have similar companies and or related or tangential companies to direct product, construction, you know, work like that, that we have clear firewalls and clear standards to ensure that the highest level of public integrity and accountability when it comes to conflict of interest are being held up. So, thanks.
Michael Van Dyke?
Just echo what Eric Schmidt said. Thank you.
Thanks. Robert Westerman?
No comments at this time, though. How the conversation develops on workforce development, I might want to chime back in. Thank you.
Great, thanks. Jack Applegate?
Thank you, Alan. I would also kind of reiterate Eric's comments. I think there was some unintentional consequences when we grouped in architects and engineers with the conflict of interest rules. I spoke a little bit on that in the rule writing process when that happened. But one of the things that this does, and I hope our architects and engineers associations might chime in. I don't know if we're invited or what the status is, but one of the things in the workforce pool that we're also going to be short of, and especially very qualified ones, and that is in the plan review certified individual category. And so in the past, we've been able to, as a jurisdiction, for instance, when I worked in the city of Astoria, we could hire a licensed structural engineer and ask them to perform plan review on a highly technical steel structure. I'm just giving a random example. Now the way the rules are, they're kind of written in contradiction with the architects and engineers' own rules regarding conflicts of interest. And so I would love to see a way that we can incorporate similar language where if these architects or engineers are performing plan review for a jurisdiction, that they also are no longer able to use their architects and engineers' license in their daily businesses, so long as they don't have those same conflicts of interest that are already written in their own statutes. So I think that's kind of it on that measure. And then, of course, the workforce development, I've kind of preached this through the entire 3 years. We and I said it earlier, we're at a critical stage and a critical shortage of inspectors and plans examiners, and I work on committees all across the country between tribal nations and military family members trying to get people converted into becoming code officials and inspectors, and that's an area we really need to work on and work with our trade partners especially, and I do that at the national level with the National Association of Home Builders, trying to be inclusive in programs. So I hope we take a close look at that. That's it.
Thank you. Garth Bachman? Garth, are you there? Okay, Dave Fleming?
Yeah, thanks. I agree with some of the previous testimony. I know when these regulations were being written, we attempted to have some discussion and dialogue on them. It was really shut down at that time through the building codes staff that they wouldn't really tell us why this language was being crafted the way it was. We were trying to work on alternatives to eliminate some what has become what I hope is unintended consequences. I hope they weren't intentional on it. So I think we certainly need to work on this language and look at, how do we do that? Currently, if you have an inspector, even for a third-party agency, and they're working in Lane County, and someone from completely the other side of the state wants to call them and discuss their building code project that they need to turn in over there to make sure they're in compliance. Currently, the way the statute's written, that's not allowed. Totally, there would be absolutely no way to really have a conflict of interest in that situation but that's what we're hoping is really some of the unintended consequences. So I'd like to see us explore some of this language and maybe even if we know, go back to why it was written the way it was, and maybe there's a need for it to be crafted this way. But I think we certainly need to explore that. We're creating problems with it, with our design teams. Thank you.
Daryl Fuller? Daryl, are you still there?
Nothing additional to add at this point. Yeah, nothing additional to add at this point.
Okay, thank you. Ed Gormley?
I have no comments, thank you.
All right, thank you. Gregory Hickelman?
Only thing to add is, hey, this is great. I think we found an issue that all of us are agreeing on, so woohoo.
All right. Nick Howard? Nick, are you there? Okay. William Scott Jorgensen?
Yeah, kind of echoing what Greg Hinkleman was saying. I see some progress being made. This is great.
Brian Krieg?
No additional comments, thank you.
Okay. Sean Miller?
You know, I'll defer to Carl Redmond on this. He's had some experience on some of these issues with conflict of interest. Thanks.
Okay. Carl?
Yes, thank you. For us on the trade side, we just want to make sure that we address conflict of interest if there's, expansions of this type of model, more third-party inspectors, which I don't really have any issue with a third-party inspector as long as they're not my competitor. And we have run into some situations where a contractor has brought us into a jurisdiction that is a little further from home, but they brought us over there because of the relationship, and then the local inspector was actually another electrical contractor hired as a third party. And most people get along well in the industry, but there are times when there are conflicts of one type or another. So we just want to make sure that at the level of inspectors who may be in the same industry of which they're inspecting, that we have some way of ensuring that that type of conflict of interest doesn't occur as this gets worked out.
Okay.
Thanks.
Aaron Reynolds?
Just for the workforce development and building official staffing piece, I think just to reiterate, a small part of this discussion, or it becomes a big part, if we were to have to hire on staff of employee that's a building official, I do know that those are in short supply, as are a lot of the certified folks out there. This is magnified by being in a small rural community. And of course, even more so with COVID-19, it's going to be highly difficult to recruit trained people to meet our needs in a short time frame, even in a long time frame. So that worries me. And as always, I think it's incredibly important that we keep our pipeline of future professionals in place and going. And so I've been an advocate of that at our community college, and then hopefully the state has the capacity to increase its ability to certify and get people out there and in this business. So I'm, of course, supportive of career technical education and getting people into this work line. That concludes my comments.
Thank you. Did anyone want to make a response on this topic?
Yes, this is Robert Westerman.
Okay. Anyone else?
William Scott Jorgensen here. Yeah, I think the workforce development issues really, really need to be addressed. I mean, within this group, without this group, the pending retirements, the numbers are pretty scary, because either way this goes, it doesn't look like there's going to be qualified building officials available anywhere. The timeline is shrinking by the minute.
Bob, go ahead.
This might be off topic for the agenda, but I think pertinent to the discussion. I sit as vice chair on a local workforce investment board for Hughes, Curry, and Douglas counties, and I'd suggest that I'd recommend you reach out to your local workforce investment boards about helping to fill the need if you have shortages of inspectors. In my local workforce investment board, we have identified as construction as one of our targeted sectors, and I believe that this issue would fall squarely under that, so might be an option to consider in the future. Thank you.
And did I miss anyone? Was there anyone else who'd like to respond on this topic? Okay. I know some of you have other appointments, and I want to be respectful of your time, so I'm going to recommend that we go ahead and combine the final two topics on our list, validation of past permits, fiscal impact statement, which is to say, you know, how to mitigate the any negative fiscal impact of our rules. And then any closing remarks you have, and I'll just kind of go down the list, and if you want to speak to those topics or anything else you'd like to say before we close it for today. As the director mentioned, this won't be our last meeting, and we hope to bring you rules at your next meeting so that we can kind of dig into some of these details a little further. But I appreciate the conversation, and I'm running out of ideas alphabetically here, so I'm just going to start at the bottom, work my way up. And so I'm asking for validation of past permits, fiscal impact statement, and just any closing remarks you have. So Robert Westerman, can we start with you?
Okay. No comments. Thank you.
Thank you. Michael Van Dyke?
I think my only comment would be around next steps, and I know that you said that you'll likely have rules for us for our next meeting. Do you have any sort of a timeline on when that would be? And would those rules be first discussed within the RAC before going out to the public, which I'm assuming by your comments, and wonder if you could provide a little clarity on that?
Sure, this is Alana. So the RAC is a public process, so I think when we bring them to the RAC, we're necessarily bringing them to the public at the same time. We need to do some work on our end to take together all of the comments we've received and also kind of work with our council and put it into a package to bring to you. So I'm hesitant to commit to an exact timeline, but we understand the urgency of this, so it's a priority for us, and we'll be in touch to schedule that meeting shortly.
Thank you.
Thanks. Dan Torres?
Yeah, so not too much more to add than the things that I mentioned previously. I think on validation of permits, I know that in the previous House bill, there was a mechanism by which we worked through that. And as far as fiscal impact goes, once again, I'll just remind folks that statutorily, the money that's used for building codes can only be used for the enforcement of building codes. And I'll also mention that, you know, one of the things that I've brought up before, but, you know, and this is not to hopefully be taken as an insensitive comment to any jurisdictions currently using them, but nobody forced jurisdictions to take on building codes programs. Many of them did for a variety of reasons, I get that, but a lot of them had gone that route 10 plus years ago because they were receiving poor service or timing or whatever the reason was. A lot has changed in the ways of e-permitting and the ways that we do the work for this. So, you know, as far as fiscal impact goes, obviously I want to minimize the impact to local municipalities, but just a reminder that, you know, this is a decision that folks have taken upon themselves to take over this program delegation and this authority. And, you know, they have plenty of options, whether, you know, like we proposed earlier, working with other people, combining resources and shared services of building officials, and or relying more heavily on Building Codes Division to provide those services and to do that work. Because at the end of the day, it was them who took that work upon themselves. And many of them, in some of the testimony that I've seen either today or previously, was 10 plus years ago when they took those programs upon themselves. So, you know, I think validation of past permits is going to be important because it's going to have a huge impact on our state. I think that's a big key of what we want to get into this whatever we end up doing. And then as far as fiscal impact statements, I think, you know, just keeping in mind there's options for shared services, there's options for reliance on Building Codes Division itself to provide these services. And so, you know, I think that should be something that should be taken into consideration when people talk about the burden of this.
Okay, thank you. Eric Schmidt?
I got nothing else to add at this point in time. Thank you very much.
All right, thank you. Aaron Reynolds?
Hello, I would just like to speak to the fiscal impact. One thing, when we were trying to come into compliance with the emergency rules, we did gratefully have a good conversation with the BCD and talking about some of those different options. So if it does come down to that again, what I would really ask for from the state is, I know it was just mentioned there are other options, but we need to have the full picture of what those options are. Right now, all I know is how it works for us currently, and that I have a great system in place where we can timely and professionally provide building services to our community in a way that works for us financially. And the way I say that is we have a system that's variable. It meets seasonal and economic ups and downs. We don't have just one home or one project a year here in Florence. We're talking about hundreds of permits and several single-family dwellings and commercial and specialty, et cetera. And so we are able to do that on a variable way by charging for what work actually gets done, or paying for what work actually gets done and inspected, versus just a fixed cost of an employee sitting there that may or may not be doing something throughout the year. And so that's a way that we can keep our costs down. So if we do have to consider a state building provided services, because we did choose to delegate the services or take on these programs ourselves, that because it made the most sense for us, I do need information from the state, actually what those fees would be, what service levels could actually be provided, and so I think that should be taken into consideration for the timeline of having to make decisions whether to keep our program or not, if it unfortunately comes to that, because that information wasn't available in the past. And then my other question is there, I missed through all the names and the people that are on this call, who on this call is speaking on behalf of BCD and what your plans are? I know, Alana, you've made some comments, but I think you mentioned the interim director. I don't think we've heard from her. Just wanting to know if there's any, like, sort of wrap-up comment from BCD that would be, like, that could be made to this group today. Thank you.
Okay, thanks. Carl Redmond?
Yes, just briefly on the validation of past permits, that's one that's very important to us. And when this issue first really got onto the front burner a couple of years ago, we actually had one of our own legal opinions put together for us on when the issue was raised, if the state determined that a program was not in compliance, and we knew that, and we purchased permits, as a contractor, do we have any liability? And our surprise answer we got back was that yes, we did. And so that's a very important issue for us to be resolved very clearly, that if we follow whatever the procedure is in any jurisdiction, that it shouldn't be on the back of any trade, any contractor purchasing permits, have any type of responsibility of knowing whether or not what's happening at the jurisdiction level has any effect on whether or not that permit's valid. It shouldn't be an issue that has to be on the back of the various people pulling those permits. And that anything that's happened in the past since this issue came up is just clarified that those were all valid as far as the contractors are concerned. Thanks.
Sean Miller?
Nothing to add to that. Thanks.
Thanks. Brian Krieg?
I'd just like to reinforce what was just said by Carl. This is a very important issue for our folks. I'm not sure whether the division can deal with this by rulemaking or whether we have to take this to the legislature as a separate item in a bill. I have a feeling it may be the latter, but smarter folks can sort that out. Thank you.
William Scott Jorgensen?
Yeah, I think out of any aspect of this issue, I would consider this one that should be and is a top priority for everybody involved. I view this as kind of low-hanging fruit. There's no pushback from anyone. It seems to me that there's universal consensus with this, and that if nothing else, if it comes down to we can't do it by administrative rule, it has to be a legislative bill, okay, fine. If you've got consensus, then everybody signs off to it, does their lobbying accordingly, and hopefully, the legislature actually stays in the building and they're able to get it passed. I'd also like to say that, really giving credit to the BCD staff here, because despite the logistical and technical difficulties, I think this has actually been a really good process. I'm really pleased with how this meeting has gone. I think we're all moving in the right direction.
Thanks. Nick Howard? All right. Gregory Hickelman?
Yeah, I got to agree with everyone on the validation of the past permits. That is an absolute key issue, and I think that's one, again, woohoo, we all have, I think, common ground here on making sure that the past permits are still valid. On the financial impact, I must respectfully disagree with an earlier comment. Yes, so we went to a third-party vendor 12 years ago, 13 years ago because of customer service, and that should be something that everybody should be in favor of, is fast customer service and getting permits validated and reviewed in plan review. If we were to go back to using the county for permitting process and plan review, I've already been told by our county commissioners that they do not have the financial resources to carry on what they're doing. So if we go back to the county, we will see a return of plan reviews that are going to take months instead of days. And what is that going to do to the construction industry here in Columbia County when we could have multiple projects going on because the permits have been issued, and we're not going to have those projects going on because the permits are delayed and have not been issued. So, yeah, there is a distinct financial impact, both for the municipalities and for the county and for the construction industry and the trades. So this is one of those things that, finding a solution to this on the building official part is key, so we can continue to have a service that provides quick turnaround of permits, et cetera. Thank you.
Ed Gormley?
I would just agree with the validation of the permits. That's all.
Daryl Fuller?
Obviously, part of the club on getting the previous permits. I mean, that's just got to be something, whether it's a separate bill or how we do it, but it's just got to be done. I am, I guess, concerned that we're in the process of redrafting rules when we haven't settled on what the statute says. There's considerable disagreement on what the statute says the rules can be, and until the statutory rules or the statutory interpretation is settled, I don't know how much progress we make on rules, but always interested in participating.
Thanks. Dave Fleming?
Yeah, just a couple of thoughts. Really, I guess my issue with the validation of permits is that I don't know that we've ever officially heard that that's a concern. I mean, it's a concern of all of us, I think, in this group, but I don't know that it's a legal issue of concern. I know the question was raised, and the issue was brought up as to whether or not that was an issue. I don't know that we've ever determined through any legal channels that it truly is an issue or not. But I would think it would be easy enough, hopefully through, if need be, through a rule or just even through some easy process to state that both jurisdictions and contractors were following the rules in place at the time that they applied for and received permits and approvals. And since they were following whatever rules were in place at the time, those permits can be deemed valid. So I would think that would be pretty easy if indeed it's even a legal issue with it. So closing thoughts, I would agree that we do, seem like we're moving kind of fast in some senses. As a member of the committee here, certainly would love to see kind of some draft language or the outlines of kind of where we think we're going with some of these issues on it. We've had a lot of testimony kind of back and forth, and I think it's great. I think we're actually coming together much better than we have in the past. Certainly, I think we are kind of far apart on some even strategies for some of this, and there's just a lot of questions that are still out there to be drafting a rule at this point. So, appreciate the opportunity. Thank you.
Right, thanks. Garth Bachman? Garth, are you on the line? Okay, Jack Applegate?
Thank you. On the validation of past permits, I agree with that's probably something that is going to have to be done legislatively. And I know that this was brought up at a Home Builders Association meeting the first time and kind of stunned everybody because we were getting calls from our trade partners right away going, what are you talking about? Nobody brought this up before. And it's not in any of the DOJ or legal opinions specifically about invalidated past permits. And so that's one of the things that I really do hope gets clarified for the trade. But I also want to bring up something, I brought it up in an email and it was submitted on there, and that's the elephant in the room. So if these past validated permits, if there is some legislation that has passed that and says they're all valid, based only on this building official issue, we still have the legal problem of there was a contract planner who worked on a permit. There was a contract city engineer who worked on a permit. There was a contract city manager who was present. There was a contract city attorney who addressed the appeal on behalf of the city. And so we may be addressing one issue potentially, but this answer has not come back from the DOJ yet, and it's something I've asked repeatedly. Senator Betsy Johnson asked for that question to be brought up in the past, and that's that, there's all these other contract services that are provided to cities and counties, including judges and city attorneys and even judges who hear cases for building code division based on licensing fines could be a contract law judge in the ORSs. And so that's something that's going to be critical, and it's something that could just put us right back in a legal tangle in the future with lawsuits on these issues of why is one specific contracted work being so heavily regulated, and why are these other ones being ignored when the state has been made aware and the Department of Justice has been made aware that these are concerns during the legislative process. So I really worry about that. And then on the fiscal impact statements, I think in the past they've been really kind of incomplete. We've heard from our jurisdiction, several of them on the phone today, that this is going to have a devastating financial impact locally to them. So there's a potential for heavily increased permit fees for jurisdictions who have to keep their program. Maybe it's the one thing that allows them to hold their charter as a city, that they have enough government work that they're doing within that agency. And the expense is real. So I disagree completely with somebody may have 10 years ago or 20 years ago implemented a program. We've had contacts from jurisdictions across the state over the last 2 years who want us to help them with their program now, and we can't. We just simply had to tell them until this legal issue is resolved, our applications are just getting turned away, and we're not getting any assistance on that matter. And so they still, in many cases, want to be able to use these services, and don't want you to forget there's a fiscal impact involved with just the simple fact that third party can show up locally to planning meetings, pre-construction meetings, all these things that many times the county cannot afford to do that. So this fiscal impact stretches beyond just the local municipality, small city, but also It affects what will happen with the counties and all of the jurisdictions around these cities where third parties helping out now, including some of the bigger counties that we hope, like Lane and Marion County, where we may no longer, because of the rules, have anybody close by to help them. And so there could be some massive shortages. So I think we just need to consider all of those things as we move forward. And lastly, like final thoughts is I think we've been rushed just a little bit, and this meeting felt rushed and a little more difficult to communicate. And so I hope we have at least a couple more meetings and potentially one in person soon, or even a work group session for a longer period of time where we can kind of work out some of these issues. So those are my thoughts. I really want to thank you and thank staff there at UCB for setting this up, though. Thank you.
Okay, thank you. So I just want to remind everyone, we'll continue to receive your public comments in writing and post those onto the RAC page. A video of this meeting will also be posted there, and Lori has agreed to give us some closing comments, our interim administrator, so here she is.
Hello, everybody. The first thing I want to say is thank you again for showing up even virtually. This is challenging, but this issue is too important to not continue to work on and continue to address. The longer we have between meetings, honestly, the less work that can get done because we lose our momentum. So it's very important that we keep our momentum going on this. To that end, as Alana stated, we'll be reaching out to everybody to try and schedule a second or an additional meeting so we can keep moving forward. It is our goal to have rules or portions of rules to be able to bring to you so that we can talk about some of these topics and actually get to the issue and language around the issue. The one thing that is really important to understand, as Director Stolfi stated, any solution we come up with must be legally sufficient and legally viable. And that's in accordance with the 3 positions that we have received from the State Attorney General, including the formal State Attorney General opinion as well. So we want to have the best solution we can, being as sensitive as we can to the issues, but it must be legally sufficient, must be legally viable. And doing things from an administrative standpoint, we will do what we can, but there may be issues such as the validation of permits that may need to go back to the legislature for clarification. Again, I want to thank you for participating. We're going to keep the train moving forward. Thank you for, particularly as we had a little glitch in our phone system, moving forward. And I appreciate your time. I appreciate your thoughts. And I can tell that everybody's taking this issue seriously, and I appreciate that as well. Thank you.
All right, thanks, everyone.
Alana, this is Ed Gormley. Could I ask you one quick question?
Sure.
Could you, next time we meet, give us statistically how many cities and counties are using third-party resources?
Yes, I'd be happy to send that to you. It's also on our, the webpage for the RAC, I believe, has a map that indicates those jurisdictions. No, that's no problem. So keep your eye on that space. Yes.
Thank you. Thank you.
I just wanted to chime in that that's not all the jurisdictions that third party is working with. That is only what you would call kind of full service jurisdictions.
Correct.
And so there's a great deal more who we do daily work with than that.
Okay. Thank you.
Thank you, everybody.
Thanks, everybody.
Thank you, everybody.